Welcome back, everyone, to A Question of Ethics. Today, we're going to talk about court rules versus procedures and technological innovation. The COVID pandemic brought the court's usage of available technology to the forefront of courthouse conversations worldwide and forced the reliance on technology to continue the work of the court. As courts evolve in practices and procedures, are courts advancing faster than the procedural rules that govern such courts? We're going to focus on Canons 1 and 2.
Canon 1.1 on performing court duties states, a court professional faithfully carries out all appropriately assigned duties, striving at all times to perform the work diligently, efficiently, equitably, thoroughly, courteously, honestly, openly, and within the scope of the court professional's authority. A court professional avoids relationships that would impair one's impartiality and independent judgment. Canon 2.1 on independent judgment states, a court professional is vigilant concerning conflicts of interest and ensures that outside interests are never so extensive or of such a nature as to impair one's inability to perform court duties.
And I would like for you to discuss the following questions. How can courts implement new technological innovations without infringing on constitutional rights? How can court administrators convince judges who are resistant to change that technology is beneficial? And what strategies can the court use to alleviate the digital divide between those who can afford new technologies and those who cannot? We will start with the first question. How can courts implement new technological innovations without infringing on constitutional rights? Peter?
Well, you can't. I mean, you have to try it out and then oftentimes have a court of appeals say, yeah, it's okay, or no, it isn't going to work. I mean, I think that's part of this whole process is that you have to experiment. And these things are experiments, and then they have to be in real time. We don't have a good process for doing this in a rarefied atmosphere. We certainly moderate that by doing them in pilot courts, experiments, so we don't affect a huge number of courts when we produce a new variation, and then see if the courts of appeal think that they're illegal. Probably the most current one that I can think of right now is virtual hearings and virtual trials and virtual jury selections, which, as best as I know, some courts have tried it, and the cases are up on appeal, and we don't know when we're actually going to hear a result as to say a virtual jury selection is going to be held legal and appropriate.
Carl, what are your thoughts on that?
My initial thought when you asked posed that question, Courtney, was that I'm not sure my impression is I'm not sure the public cares. I often think we're more cautious and mindful of preserving direct public access and preserving their constitutional interests than the public is. I know when on that rare occasion when a judge here will deny a request to appear by video, for example, and require an in-person appearance, most of the time the public or the party is annoyed that they have to come there. Right? I just have the impression that most of the time, with the exception of defense attorneys in high-level felony cases, for example, that the public just that's not an issue for most of the public. I just wonder if we're being cautious and preoccupied with something that is already mostly a settled issue for the public.
What about things like waivers of counsel that are required on certain cases? The public may not mind, but we are still required, whether it's by law or by court rule, to acquire those signed pieces of paper. Where are you guys falling on that? Stacy, I would imagine a portion of your population is pretty spread out. So how are you guys handling acquiring those documents?
Well, I can speak specifically toward jury service. We did change one of our rules a few years ago to allow for electronic documentation rather than paper, which was required before. So we made a little bit of a rule change there.
locally or at the Supreme Court level?
It's in our court rules, so the Supreme Court level.
So there are a variety of technological solutions which are out there. Again, some of these are going to have to go up on appeal and to see if different states are going to approve of them. I mean, the one that I know of is DocuSign, to be able to provide an electronic signature. I heard of one court, and they had about one of the most interesting solutions I had ever come across. If they had an agreement which needed to be signed, and this was they had virtual mediation. And if the parties come to a resolution and they crafted a written document that needed to be signed by all the parties, and they wanted to get it done that day in virtual, they had a courtroom clerk come on the virtual mediation and then had each party give verbal waiver and approval to the clerk, signing the clerk's name on the document for the party. Pretty interesting.
Wow.
If that's going to hold up, nobody knows, but I thought that was out there, the clerk sits there and says, please recite to me this line. I assume that they would have to recite a line that says, I give full waiver and approval that this clerk is signing my name to this agreement in my stead.
Wow. I wonder if that has been questioned. That's
I would be shocked if it isn't going to be questioned, but I mean, that's the kind of innovation that I think, that's how you go out there and you try something new, and if it works, great, and if not, I guess the appellate court sort of slaps you down, and which
it seems like a lot of these things are very reactionary, and some things, some court procedures get put in place out of perceived convenience, and such as, having a clerk sign. That's a lot on that individual clerk, number one. But I also think that for the exception than the rule, in my experience, that states like Alaska with Stacy that have already implemented those rule changes. I'm not seeing a lot of those rule changes being made anticipating that this is the direction that we're going to continue to go. I think things still seem to be very reactionary. And I think that's going to be interesting. And I think eventually things like that will come to a head. I mean, the jury trials that were done virtually and all of that's going to potentially have to be redone. And I think that is going to impact us at some juncture as well. As court administrators, would we be comfortable with asking a clerk to do that? I don't think I would. No. Joe, what are your thoughts on that question?
I wouldn't be comfortable having the clerks do that either.
Go
I'm
ahead.
sorry, I'm just curious, why is that? Why wouldn't you be comfortable doing that?
I wouldn't, because I don't know that they have the authority to do that. The court is asking another officer of the court to act on the behalf of a party in the case. And I think I don't know. I think that's tiptoeing into some areas that the court shouldn't be in. I think that would be hard for me. At least that would be my response. So on the flip side, and going back to the reactionary discussion, if you have a court administrator, if you're a court administrator, how can you convince a judge or judges that are resistant to change and show them that these technological innovations are beneficial? Kent, I feel like you've been in this position before.
More often that comes from peer experience. It's very hard for a clerk who's the court administrator in Virginia. We don't have really separate positions to exercise that kind of influence. So it more often comes either from state level down as a recommendation, or it comes from peer experience from another court. So it's not really a court administrator's worry unless they really just have a good relationship with their judge or judges, and they hear from their own peers and bring it to the judge to consider. But I don't know that it's really an ethical challenge as much as just a matter of introducing new ideas and seeing what comes of it.
Then, so looking at it from that perspective, I guess the question would be, is it in our wheelhouse to present these technological innovations, to be on the forefront of them, to look at changing the way things have always been done? I mean, we know the last 2 years have shown us that can certainly be beneficial. But again, it's that implementation, I think, that becomes the ethical question for the courts. But with the change to technological advances or innovations, what strategies can the court use to alleviate the digital divide between the new technologies of those who can take advantage of them and those who are unable? Carl, you guys are pretty spread out there in areas. How are you handling the digital divide?
Yeah, I may have, in an early discussion, I may have mentioned this scenario before. We started to live stream our high volume arraignment courtroom about 1.5 years ago, and the Supreme Court was very concerned about the digital divide and thought, well, we still have to maintain an opportunity for public access, even if people don't have a cell phone, even if people don't have internet access. And so they imposed a requirement where for anything we live stream, we also have to stream it to a large screen in a public area in the courthouse, so people can still come to the courthouse and watch it that way if they're otherwise unable. But the curious thing about that, though, and so we set it up in a remote area of the lobby, we set up some seating, and people will sit there with their cell phones in their laps, watching the live stream on their phones and the live stream on the screen. Same image, same audio. I just, in our experience, as much as that's a concern, and we hear that, we discuss that all the time, and I've seen conflicting research, and we probably have too, about just how much a divide there is. But boy, I get the impression that there isn't much of a divide. And that, once again, just sort of like the first question, this may be an issue that we're more cautious about and concerned about than the public is. I get the impression, in a, just like Alaska, in a state with low population densities, that even in those rural areas, the public's pretty well connected.
This question about the digital divide, I think, is very interesting in the respect that we've always had a divide. It wasn't called the digital divide before. I don't know if it even had a particular name. If I was going to give a name to it, it would be, before all of the technology, it was the geographic divide. I can't make it to the courthouse. It's too far away. I don't have a car. The bus doesn't go in this way. I mean, I've got too many other things that I've got to do. I got to get kids to school or something. And for years, decades, we had a solution for that. It was a bench warrant. If you didn't make it to court, they issued a bench warrant, and then you either came to court and you pled your case that I couldn't make it that day or something, or you were arrested and taken into custody, and then you appeared in at least an arraignment court or some other initial appearance court, or you were able to avoid, the service of the warrant for so many years, and then eventually it went away. So we've always had that. It's just recently now that it's been converted over to a digital divide. And I think we're still trying to ferret out what the results of that are.
I think the part of the struggle for me is in the ethical realm is the application of some of these things. So previously, to Peter's point, a bench warrant would be issued. Okay, well, now it's like, oh, well, maybe that was your internet out. Oh, it was? Okay, well, then we won't issue the warrant. As been before, you weren't in the courtroom, you weren't in the courtroom. Are we still applying? Are we still applying justice, if you will, fairly and equally if we're holding people to different standards? I don't have internet, so I have to come to court, but if I'm not in court, then you're going to issue a bench warrant. But if somebody does and they maybe their internet goes out and then they call and say, oh, well, my internet went out, so I couldn't, how can we prove that? We can't definitively say that person wasn't in the courtroom or their internet was out. Or so I think there's some challenges along those lines. I do see that continuances have gotten far more liberal with people coming to court or missing court. You know, we never made anybody show that they had a positive COVID test to come to court. We would just automatically give them a continuance. And oh, do you have access to join us virtually? You're positive. Oh, no, I don't. Well, we don't know that they do or they don't, as where if somebody doesn't have a positive COVID test, we would have issued a bench warrant for them. So I think there are some challenges in that realm. Has anybody faced anything in those regards in their court?
The challenges that I've become aware of in these types of scenarios where we're talking about a digital divide have involved bandwidth and the court trying to make sure that the proceedings are fair, where you may have a remote participant who has the technology to participate, but their bandwidth is such that maybe they can only participate, via audio, and other participants are there in the courtroom. Everybody can see and hear them. Does this person whose audio may or may not be good hear everything that's going on in the courtroom? Does the fact that they can't be seen, can't participate as well, does that create a bias that affects the outcome of the case? And what does the court have to do to level the playing field so that somebody is not, harmed by that type of circumstance? And that could be in rural areas, or it could be in urban areas where they don't have as good a infrastructure for the higher bandwidth.
So in our last couple minutes, Joe, tell us how we level that playing field out.
That there have been some courts that actually have been providing devices to people who are indigent to sort of level the playing field, or maybe offering more locations off-site that people can go to and utilize better technology that they don't have at their homes. I guess one thing I was going to say is that it's not really a digital divide, which to me sounds like a binary. Either you have internet or you don't. It's almost like a spectrum, like Kent was saying, like some people have high-speed internet and some people have really spotty internet.
Yeah, and so often I think when we talk about a divide, it's the same divide we've been struggling with for a while. It's not necessarily technology and access and equipment. It's sort of personal capability. For example, whether you're in Kadoka or Caligonic, if, for example, your library has access, but you've never been to a library, you don't even know your town has a library because you've never set foot in it. Those sorts of personal lifestyle and personal capacity issues, I think, have much more of a bearing on a divide when it comes to access than equipment and technology.
It seems like this is just the next logical iteration of a road that we have been on for generations to try and extend equal access to people, and it's now just moving into a new area.
Well, thanks for joining us today. We will see you all again on September 22nd.
Thanks for joining us today. A Question of Ethics Conversation is a regular segment on ethics, courts, and court administration. Today's episode will be available on our website, in the Court Manager Journal, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on Twitter. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is ethics@nacomnet.org. Did you hear an interesting comment by one of the panelists that you'd like to listen to again, but you don't want to search the entire episode to find it? The Additional Resources section on the web page contains a question time marker sheet. Just find the discussion question on the sheet, and next to it was the time that question was asked. You can then quickly fast forward to that time on the episode and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.